Welcome to the Computational Antitrust podcast. My name is Thibaut Schrepel. I'm a faculty affiliate at Stanford University Codex Center and the creator of the Computational Antitrust project, which explores how legal informatics can benefit antitrust law. The project gathers over 50 competition agencies and 35 academics in the advisory board. Each month, we publish an academic article on the subject of computational antitrust. You may find them at computationalantitrust.com. Today, I am thrilled to be receiving three gentlemen who co-authored a paper for us entitled Antitrust Enforcement and Big Tech After the Remedy is Ordered. First, we have Jason Nieh, who is a professor of computer science at Columbia University. He was also, as we will discuss today, a technical advisor on the Microsoft antitrust settlement and in the United States versus Bazaarvoice. We also have Jason Himes, a senior counsel at Leviton Sucharo. Before joining the firm, Jay was the Antitrust Bureau Chief at the Office of the Attorney General of New York, during which his responsibilities included working on the Microsoft case. Jay also served as the court-appointed monitoring trustee in the United States versus Bazaarvoice case. And last but not least, we have Ron Schnell, a computer scientist with more than 40 years experience in the field, including work at the Bell Labs, IBM, Sun Microsystems, and research at the MIT and New York University. He is currently a director at Berkeley Research Group. Previously, he was the general manager and chief executive at the Technical Committee, the organization that monitored Microsoft under the final judgment. Besides his consulting work, Ron is currently an adjunct professor of computer science at the Nova Southeastern University. Gentlemen, welcome. I'm delighted to be with you. I thought maybe before we get started, if we could do a quick roundtable. I'm curious to hear first, how are you doing and where are you currently located these days? Please, Jason.
Things. I'm in New York City, which was, as you know, the epicenter in the U.S. regarding COVID pandemic. But things have gotten much better here with the vaccines. The COVID positivity rate has gone way down. Traffic is now starting to pick up in the city. So things are slowly getting back to normal.
Too crazy, you mean? In New York.
Yes.
All right. Thank you. Ron.
Yes. Well, currently I'm in beautiful, sunny Miami, Florida, this is where I nominally am, although I find myself in pretty high demand as a testifying expert these days, so I travel all over the world to do that.
All right. Excellent. And Jay, how are you doing?
I'm okay. I'm alternating between New York City, where I would ordinarily live, and a small country home that we have about 100 miles from New York City in a place called Mongop Valley or Monticello, which is about 5 miles away from the infamous Woodstock Festival. When the virus was quite serious in New York City, my family spent the better part of 2020 out in the country. Now, as I said, I'm alternating back and forth. Right now, I'm in the country.
Excellent. And so, before we started the recording, we asked you to close the window because the birds were too loud outside. So this is the environment in which you are right now. And I think I can say I'm really jealous of that, but that's okay. I'll manage.
The bears, however, are very quiet.
Very quiet. Excellent.
And you're lucky that the alligators don't make much noise here, so you can't hear them.
Exactly. Yeah. I thought it would be also a nice way to start, and I thought if one of you, or it could be all of you, could actually take us through the paper that you wrote for us in 2 minutes or so. What's the main takeaway from it?
One is that in a monitoring environment for an antitrust case, you need to expect the unexpected. That there will be unforeseen effects, issues, objections, and the court decree that you're operating under isn't going to cover everything. And the second takeaway, I would say, is to be skeptical as a monitor when you're met with a company response that reflects resistance. It'll take too long. It can't be done. That's not the way we usually do it. Things like that. And that's really where the ability to probe into the systems and, if necessary, into the people by interviews is really critical, and technical expertise is just essential to get behind those kinds of objections.
And it seems that the more I speak with competition agencies or antitrust agencies those days, the more concerned they are about those issues. And so for that reason, I think your expertise and the years of experience that you have in the field are incredibly valuable. I'm not sure if Ron or Jason, if you want to add something to this.
Sure. Prior to working on the Microsoft case, I couldn't have imagined what would have happened if there was a final judgment on a high tech company who would make sure that it's enforced. I guess maybe I envisioned in my head some genius judge or special master doing things, but it didn't occur to me that somebody needed to do it. So it really ended up working out perfectly in my mind that we had this team of very technical people who could monitor what was going on and report to the plaintiffs so that things could be properly enforced.
And I guess the same could be said nowadays for regulation, right? Because you do need also to monitor and to enforce. So that's a subject I want to discuss with you. Jason, maybe you want to add something.
Yeah, I would just echo Ron's comments and Jay's comments as well, that whenever antitrust is applied to a computing or a technology company, right, then fundamentally that the technology in question is actually a key aspect of the antitrust enforcement. And so often technologists are not involved early enough in the process to frame that problem and understand the timeframes that in which things need to be done in order to address those kinds of technology questions. But fundamentally at the heart of it, the technology question is one of the key questions that arises in this context.
Just to give you a little perspective, going into the remedy phase of Microsoft, I don't think that the Department of Justice was necessarily imagining an enforcement monitoring structure of the kind that evolved. Historically, the Antitrust Division did not use outside groups to monitor antitrust decrees. And I can recall, being with the Department of Justice people at that point in the case, and they're saying, we monitor our own cases. And that really was the direction that antitrust remedy enforcement had come from. A DOJ overseeing, for example, the ASCAP decree from years ago. And I mean, that was a circumstance where all the monitoring was done within the DOJ. It didn't involve, of course, the technical level of issues that Microsoft involved, and so it was feasible. But that really was the historic pattern. And we did something quite different, obviously, when we created the technical committee run by non-lawyers as an interface with Microsoft.
Yeah, and I'll just add that in this case, in the Microsoft case, we were dealing with issues literally down to the bit level. I mean, we were talking about which bits were on communications protocols. I'm sure we'll get into that a little bit, but I don't know whether that's, clearly the DOJ would have difficulty dealing with that on their own. Earlier cases I was alive for, I was a kid for AT&T and IBM. Even though those are highly technical companies, I don't believe that their issues got into the bit level, even though there were technical issues from what I remember, things like, compatibility between long distance companies and things like that. Those are technical issues, but I don't believe they got into issues down to the bid level like the Microsoft case did.
So, and that's something that you explained very well in the paper, because of course we all, I mean, if you are in the field of antitrust, you do know that the Microsoft decision led to API and communications protocol disclosures. But I have to admit that I never measured the scale of the endeavor. And so you explained that very well. So a few numbers here. Microsoft first committed 10 employees to writing the documentation in 2002. By May of 2006, so 4 years after, they had over 210 employees involved in the process, including 150 product team engineers and program managers. 3 years after that, the project included 400 Microsoft employees, eventually working over 6,000 technical documentation issues at the same time. So this actually led me quite recently, when I was exploring the recent AI regulation coming out of the European Commission. What you find in the report is that the European Commission basically imposes that if you put AI in an environment which could create a risk when it comes to controlling AI, then you should run the test and write the documentation and disclose that to the European Commission. And they do say that the cost of doing so per product will be under 10,000 euros. And when reading your paper, I thought, well, it seems that we are far away from reality. And again, it seems that we are, going through the same path of believing it will be easy. And at the end of the day, it's not easy. So my question for you is the following. Why is it so hard to produce these disclosures and documentation?
Well, I mean, I can say in the Microsoft case, I think it's quite different than what you're discussing. The issue is in the Microsoft case, tens of thousands of pages of documentation had to be created from nothing, essentially nothing. Microsoft said in court that they did not have any documentation for many of these protocols. And it's interesting that the way the final judgment was worded, it wasn't specific as to, for example, which communications protocols needed to be documented. So therefore, we had to monitor the creation of documentation for protocols that hadn't been used in 20 years. Things like NetMeeting, for example, which at the time many people didn't even remember existed. So there, not only were there a lot of protocols to document, there was a lack of documentation and internal knowledge. A lot of the people who worked on those old protocols had left the company long ago, with their stock options having made them very wealthy.
So nobody knew, right? It was true for the DOJ, but also within Microsoft, they never measured the scale of the endeavor. Is that fair?
In many cases, that's true. Yes, of course, in the very modern protocols, there was knowledge about what was going on, but certainly they would admit, and they have admitted, a lack of documentation.
And the final judgment itself was rather general. It described those protocols that had to be disclosed by a function, basically. What generally did they do? And so within that, you had to drill down into the specifics. And I think what Microsoft discovered and what we certainly discovered was drilling down was not easy.
Jason, anything you want to add on that?
Well, I think the other aspect is probably also the case that sometimes, especially for a technology company, it's much easier to go forward, right? Because you're going forward. There's a business, there's a financial incentive. You have real users to actually try your products. Here was a case where they had to go backwards, right? And so there's, I would say, there's a little bit of a disincentive to want to have to do that, right? The financial incentives are not there. Engineers want to work on new and cool things. They don't want to go back and document old things, and so that I think that whole process then becomes much more difficult as a result.
Yeah. And I would say probably one of my proudest moments during the whole thing, as a technologist, as an educator, was when Microsoft said, this turned out to be good for us to actually have documented these protocols that we wrote in the past. It's actually helping us with other things. So that was, I think, a great moment in this enforcement.
But when was it that they say that? Was it at the very end of it, or
No,
in the midst of the...
It was, I'd say, the middle of it.
Okay, interesting. And so this leads me logically to the Bazaarvoice case, which led to different yet similar issues. And this makes me wonder, what about antitrust agencies? How many employees are you aware of? How many employees were working on the follow-up of those remedies in the Microsoft or in the Bazaarvoice case? Because I imagine if Microsoft had to have 800 employees, the DOJ was probably overwhelmed at some point.
I don't think we were ever overwhelmed. We certainly ramped up the engineering resources of the technical committee. And this began as a group of three people, but as the work intensified over time, Ron knows better than me, but you were bumping up against 40 plus near 50 engineers working full time. So I don't think we were overwhelmed. I think probably there were times we overwhelmed Microsoft.
Yes, that's probably accurate. I mean, I hired a total of 93 people in my 6.5 years
Wow.
tenure running the operations of the technical committee. But I think more to your question, the agencies themselves, they kind of relied on us. They didn't, I wouldn't say they ramped up very much. I think it was 19 attorneys general, Jay, who were.
Well, yeah. I don't think the lawyer resources did ramp up. I would agree with that. We did rely on having people, out there on the West Coast who could deal with Microsoft on a day-to-day basis. And we did not ramp up in Bazaarvoice either. So, I mean, I was relying on Jason where I needed technical expertise. And the remedy was quite different. The remedy was to operationalize a data stream that that Bazaarvoice was receiving from power reviews, and of course they had never had to do something like that, but that was the essence of the final judgment. Take in data reporting product ratings and reviews, and that's coming in on a daily real-time basis. Bring it into your system and display it publicly. So it was quite a different exercise than creating technology that would be available to industry participants and engineers at large to be able to implement in their own products.
Indeed, the interoperability part is more pregnant, I suppose, in the Microsoft case in this situation. But I'm curious, coming back to the fact that you had to hire so many employees and experts in just, I mean, you said in 6 years, but still, I mean, that's quite a lot. How did you manage that? Was it, to make sure you hire the right person, you can actually provide them with the right salary, the proper incentive, and so on?
Well, we had the benefit of having all of our expenses paid by Microsoft. And because of that, we were able to attract really, I think, the best talent in the world. We paid, market rates at least in all cases. I think the difficulty for us in getting all those people was that, 2 of our 3 offices were in the Seattle area, and people in Seattle love Microsoft, and a lot of people considered our organization to be anti-Microsoft and did not want to work for us. And that's probably the main reason we started hiring engineers in Palo Alto, because it was much easier to find people willing to do work, what they considered against Microsoft, than it was in the Seattle area, that where millions of rich people had been created by that company. A lot of wealth had been created by Microsoft.
Yeah, indeed, I imagine. And so, um, so several times I had the occasion to discuss the Microsoft case with Judge Ginsburg, who told me that um, technical experts were going to the court on a regular basis to explain the functioning of an OS, because at the time, none of them at the courts have heard about an operating system. But now, looking at the future, I do have 3 questions for you. The first question is the following. You write in the paper that software engineers should assist enforcers, courts, and agencies in understanding technologies and monitoring the remedies. So my question, and I realize this is a complicated question, but should you work for the FTC or the DOJ Antitrust Division these days, how would you proceed in terms of recruitment, but also in terms of integrating these experts into the entire judicial process and not just at the end of it or, the very beginning of it?
Well, maybe that should be directed first to me. I think the technology level that exists in the agencies today is much greater than it was at the time of Microsoft. I mean, there was not a resource really dedicated to dealing with technology the way there is today. The consultants didn't exist in-house. And we didn't have that in the AG's office, although we had a technology group, but it was run mainly by lawyers. And I suppose we did have small technology resources. But today you're seeing much more commitment to having that group in-house. Now, I mean, if you get to a lawsuit, you're going to need some expertise from the very outset, from the investigation. And I don't know the details of any of the tech investigations that resulted in cases today, but it would be my working assumption that there were software consultants involved at some level, whether they were retained or whether they were dedicated personnel within the agency or the state AG's offices. I would expect that. Certainly, if you are looking towards what's going to happen at a remedies stage, you're going to have to make the same decision. Are you going to handle the technical work within the public sector by dedicated employees, or are you going to create something like the technical committee that we used for Microsoft? And you can talk about what the advantage or disadvantage of doing each is. Principally, I think you've got greater flexibility if you go outside, but then you have to create a structure from scratch, and that's that is not necessarily easy. Or you have to retain an outside firm with that capability as a retained consultant, where you have an existing structure already in place.
And what was the main concern at the time?
We did not have in-house the ability to monitor, as Ron said, at the bit level. I mean, we didn't know we were going to have to monitor at the bit level, but we knew from the existence of affirmative disclosures that we were going to have to be able to evaluate the product, the software that was coming out in any technical documentation, and there was no capability of doing that I know of in-house at either any of the enforcers. So we had to have something else. And I knew that going in to the settlement discussions, that somehow the nature of what was going to come out of the settlement or of a court-ordered decree was going to require technical expertise. There just was no doubt of that. And we had to get it somehow.
Maybe let me move on to the second question. This one relates to computational law. I wonder if today, with today's technologies couldn't help courts and agencies in the matter. So, for instance, it seems to me that AI could help with the implementation of certain specific remedies, while blockchain could also help with the monitoring of those remedies. So I'm wondering, what is your take on that, and which technology you think could help antitrust agencies in again, implementing remedies and monitoring those remedies?
I think my take is that computational law, as in actually applying computing directly to legal problems, is still largely in its infancy, right? And I think it'll be very interesting to see how that evolves over the next years. I think our primary experience has been where law intersects computing, because computing-related companies were subject to antitrust monitoring. But I think the broader question you asked, which is applying computing to law, I think is a very interesting and open problem that lots of folks are working on. I mean, law as it is I'll define it as somewhat squishy compared to, say, programming or programming languages, right? Things are sometimes a little gray, not so well defined. For example, there's work on trying to be able to more formally specify law or describe it in more formal languages so that computing could actually take a much more active role as an agent of law, as opposed to the way we use it today. So I think the area is certainly an interesting area, and an area that I think will evolve significantly over the next few years.
But so far, you never read a paper in the field of computer science and thought, well, this would have been handy. Should we have that technology at the time of the Microsoft case?
Well, I would say that there are certain things we did in the Microsoft case that would fall under what you're talking about. So one of the things we had to do was not only verify the accuracy of technical documentation, but but to look for completeness. So how do you find a lack of documentation or secret protocols, or I shouldn't say secret, missing protocols. So what we ended up doing is instrumenting Microsoft's test labs all over the world and capturing all of their test data at wire speed into unheard of storage devices for the time, and then programmatically the network traffic was compared to the XML marked up technical documentation that had been produced. So I think that's kind of an example of what you're talking about. In terms of the future, I've seen a lot of settlements or proposed settlements where companies are ordered to do things like not put certain things on their web page, not link to certain other web pages, not have Google ads for certain things. And certainly that could be handled by, I don't know if you'd call it AI exactly, but you could have computational programs to do that sort of thing. So I think there may be parts in every big tech action or settlement where you could find something automated to at least help you.
Indeed, I mean, that's my hope, but that's my personal bias. You do give several concrete tips in your article. Ultimately, I think it's fair to say that the objective seems to be to humanizing the monitoring process while making sure that the company is never, and I quote you here, too far away from the monitoring. So I'm wondering, could you take us through the top priority in the matter of making sure that the environment remain human-centric and not something which is obsessed by and for the technology?
I think that's a real challenge, in part because of comments earlier that the company's incentives are not perfectly aligned with the enforcers' incentives and the monitors' incentives. Basically, they want to get through it. they want to get past whatever the monitoring is, and they don't want to be in a position where you could argue to the court they're being obstructive. They want to project cooperation, but in the end, this is something they're being ordered to do. It's not something that they chose as a business matter generally to do. It's interesting to hear Ron's comments that Microsoft found that we were actually accomplishing something that benefited them from a business point of view, but that's kind of collateral benefit, if you will. Certainly not the intention of the decree itself. So, getting people's attention to the importance of what you are trying to accomplish at the detail level is something that is a challenge, and I think you have to do it, with pretty regular contact. We had the benefit in Microsoft of technical people who were talking to other technical people day to day. And I think, that helps, but Bazaarvoice wasn't the same thing. We certainly were talking to our liaisons and to engineers on a regular basis, and we had regular access if we needed to be able to talk to them about something. But Jason wasn't on the ground, so to speak. He wasn't out in Austin, talking to them, going over to meet with them. He didn't have systems feeding directly into him all the time, the way the technical committee did. So it was a different environment, and the nature of the remedy is going to define how you can function. I think that the technical committee, in dealing with very intense technical problems, worked, and we were always there. Now, I hate to go on because maybe the others, Jason and Ron, can offer their views about how you can sort of get the company to be rowing in the same general direction as you.
Yeah, and if I may, Jason, I'm curious to hear what was your experience? Since you worked on those two cases with a totally different process.
Well, I wasn't in Texas as Jay mentioned, so I was definitely more remote. Yeah, I would say the TC, for example, in the microspace was much more hands-on, everyday involved than my involvement in quite frankly either of the two cases. But I think that uh, one distinction between the Microsoft and the Bazaarvoice cases was that in the latter case there was another party that was heavily incentivized and was on the ground all the time to interact with Bazaarvoice on a regular basis. And because of that, I was able, in some sense, to leverage their feedback or their experience to be able to then identify and say, with Jay, right? Hey, here's a problem, and how do we operationalize that and fix that, and then have regular feedback from this other party to then say, did it work or did it not work, and then go back. And so I think that made my job much easier, and also made it possible to do my job in that case at a smaller scale and still be effective, as opposed to having to hire an enormous team of engineers, for example, to make it happen as was required in the Microsoft case.
Yeah. Thank you very much, Ron. Anything you want to add?
I'll just echo that having, being on the ground was critical to our success. I mean, there's no question about that. I mean, I was on the Microsoft campus every day when, those days that I was not meeting with competitors and partners and things like that. And I also want to add that, I was very lucky to have, the three people that Jay mentioned, Harry Saul, Skip Stritter, and Franklin Fite, who were the court approved members of the technical committee. And they, when they came in, quickly realized they were going to have to build this organization, actually corporation, and eventually brought me in to run it because of the amount of on the ground stuff that needed to be done. But they were they are very well respected people in the industry, and they wielded that respect, and Microsoft sort of knew they had to cooperate, and those members allowed me to run this organization on the ground and do what we needed to do.
So let me follow up on that, if I may, and this will be my final question for the three of you, actually. Building on your experience, what would be a concrete tips that you will be given to antitrust agencies? Because there are so many ongoing investigations, so many agencies, pretty much all of the antitrust agencies nowadays are, after some big tech or medium tech companies. So they're going to encounter the same issues. So what is the one thing you would like to emphasize based on your experience? And I guess, I mean, being on the ground and working with the people is kind of the direction that the three of you underlined already. But is there anything else that you would like to offer? So Ron, maybe.
Well, I would say that get technical people involved as early as possible. Even I would say that the final judgments in these 2-3 cases were written with technical knowledge, but not to the bit level, obviously. Perhaps if there were even earlier involvement, you would have some more guidelines. I mean, it was a very well structured document. I mean, it was our Bible for 6.5 years. We knew exactly what we had to enforce, but I guess perhaps if technical people were involved earlier, it might have had more. We might have had a little more guidance, but not that it was a problem, but it could have been different. I don't know. Yeah.
Yeah. Thanks, Jason.
Yeah, I would definitely echo what Ron said. The first thing that comes to mind is getting the technical people involved as early as you can in the process and throughout the process. And I suppose the other thing I would say is when it comes to these technical matters, what might appear maybe simple at a sort of very high abstract level, that when you actually get down to it, it ends up taking much longer than you expect. And so, just like building real products, so really making sure that you allot for that in terms of resources and time, I think is very important to effective monitoring and enforcement.
Thank you. Now, Jay, would you say the exact opposite?
No. I agree. I think the earlier that you can get intelligence at a technical level, the better off you're going to be
Yeah.
in both proving your case on a liability phase, and in coming up with a remedy that that can be implemented and work. So I think the technical expertise as early as possible is simply critical.
Well,
And I would also add this, there are so many investigations going on globally. I think you also want to be clear at that the enforcers around the globe have an ability to collaborate with one another.
yeah.
And that should be doable. But it's maybe not the easiest thing in the world, but I think you want to be able to learn from each other insofar as that's possible.
Well, that's a perfect way to end this podcast, because that's exactly the goal of the Computational Antitrust project, in which we gathered all of those agencies. And I've been very pleased to see the reaction, and all of those agencies immediately said, yes, we want to be part of that. We want to exchange information and expertise. So, and I know that several of them are listening to us today. So thank you very much for sharing your experience and your vision about the field. I hope to see you soon in person, maybe in the forest among the birds and the bears and the alligators. And until then, take care, and I'll see you soon. Bye-bye.
Thank you
Thank
for having
you.
us.
Thank
Be
you.
well.